Hi, this is Amy Quackenboss, and I'm here at ABI Georgetown's View from the Bench program. And with me today is Phil Anker of WilmerHale in New York. And Phil just moderated a panel on 546E safe harbor provisions. Welcome, Phil, and thanks so much for moderating that panel.
My pleasure. It was interesting.
Right, and so you spent a lot of time on the panel talking about the recent Supreme Court decision of merit management versus FTI. What does that do to safe harbor provisions?
Well, I think it narrows potentially one set of arguments for a broad application of the safe harbor. The safe harbor applies to a transfer that is by or to or for the benefit of certain enumerated entities, financial institutions, financial participants, stockbrokers, and others. And what the case holds is that if the only role of a financial institution or other covered entity was as an intermediary, not the actual transferee who received the money or the stock, or other security, that isn't good enough. But the safe harbor continues to apply if the real transferor and the ultimate transferee, if either was a covered entity of one kind or another. And the opinion notes that there are lots of potential grounds for such argument. There's a footnote that says it can end up pointing to the definition of financial institution, which includes not just a bank, but potentially a customer of a bank if the bank is acting as agent in connection with a securities contract. So I think the safe harbor could still be quite broad.
Right, and you mentioned during the panel some workarounds to the merit case and what folks can focus on. Can you tell me about that, and is that finding success?
Happy to tell you about it. It's finding mixed success. So the safe harbor is in the bankruptcy code, and it applies by its terms to an action brought by a bankruptcy trustee. And as we all know, in bankruptcy, that includes a debtor in possession. The workaround that has been attempted is to say that one way or another, we will basically have a bankruptcy trustee or the bankruptcy estate abandon the right to bring state fraudulent transfer actions under Section 544 and instead allow creditors to bring them as if there were no bankruptcy. Various arguments have been made on the defense side, including by my firm in certain cases, attacking that. The only circuit level decision is out of the Second Circuit. It holds that that workaround does not work, in fact, that federal law preempts state law in that regard. But there is contrary decision at the bankruptcy court level in Delaware, and there were at least one or two contrary decisions in the Southern District before a tribune, the Second Circuit case. And that case is now back in front of the Supreme Court, and there may be motion practice in the Second Circuit in light of merit. There is motion practice, I should say, to limit it. So what the ultimate result will be, time will tell. We'll see.
Great. Well, maybe next year at Views from the Bench we can report on what the result is. So
that'd be great.
Thank you, Phil, for joining us here, and
pleasure.
Thank you for everybody for joining us. If you want to find the full recording, you can find the full recording of the session on abi.org, our website. Thanks so much.
Thank you.